Hi, everyone. This is Mike Dzwonczyk. I am, along with Mr. Park, a member of the Sughrue Mion firm in Washington, D.C., and I'm coming to you this evening from my home office just outside of Washington. I know we just heard from people in Seoul. First, let me thank KOTRA for inviting Mr. Park and I to join you tonight. It's a pleasure being here and a real treat. We are going to talk for the next bit of time about challenging patents at the US Patent Office. And what I'd like to do to get started is try and pull up a slide deck that we had put together. We're going to talk tonight about challenging patents at the US Patent Office. Very briefly, we're going to talk about 2 or 3 of the more commonly used, the popular proceedings at the Patent Office. And we will compare that and contrast it to challenging patents in district court, in other words, in our federal district court system. Of course, tonight's presentation is really just for education and for your edification. Obviously, it doesn't constitute legal advice in any way, shape, or form. Okay, the question that really get us started is why challenge patents? Why do we bother going through the motions and the exercise of asserting that a patent should not have issued or is invalid? Well, very typically, in the course of its business, a company will identify patents owned by others, perhaps competitors, that are relevant to perhaps its own product lines or its methods of conducting business. And they come across those patents in different ways. Sometimes they have a dedicated individual or individuals in-house that actively search worldwide patent databases simply to determine what competitors are doing and to see whether anyone has issued patents that may cover their own products or activities. Oftentimes, a company will engage in a due diligence analysis. For example, when it is considering an acquisition of a product line or a company, or even if it's investigating getting into a new area of research or manufacturing, it will diligence the acquisition or the new business model, and in the course of that work may come across 1 or more patents that are relevant to their current product line or lines or their current operations. A freedom to operate analysis is a study undertaken when a company wants to see what patent families are relevant to, I'll say, a particular product line or an area of research and development or an area of manufacturing. Before a company prudently gets into or embarks on a new business venture, it studies the IP landscape to see who owns intellectual property in that area that might be relevant to its consideration. And finally, patent prosecution. Companies engaged in obtaining their own patents will frequently learn about a competitive patent during the prosecution of their own patents. Typically, the examiners will bring these patents to light, and oftentimes that's how companies first learn about patents that might be relevant to what they're doing. Probably the least desirable way of finding out about a competitive patent is if a company receives a letter from a competitor or from a patent owner saying, look, we believe that your product or products or one of your methods of manufacturing is covered by our patent, and we want you to stop. This is the kind of notification of a patent that you don't want, which is why companies engage in a sort of proactive searching described on the previous slide. So when you are informed of a competitive patent that's relevant to your activities, the very first question companies seek an answer to is, well, does in fact a product that I am making or a method that I am employing, does it infringe the patent? You know, I see that from my cursory review that the patent's relevant, but Now you have to actually undertake a study to see whether or not you infringe. Suppose it's not an existing product, but a product you're planning on launching in the future. How soon or far in the future is that date? And when does the patent expire? It may be the case that if you have a planned product launch for something next year and the patent expires, it may be much less of a concern to you than if the patent is going to expire, in 2030. If you do identify the patent and you undertake an analysis and you determine that your product infringes the claims, the next logical question is there any way to design around the claims? Can I redo my design, change a step in my manufacturing process in a way that avoids the patent? And oftentimes, this is the this can be the least expensive and the least involved way of avoiding that cease and desist letter or avoiding a patent that might otherwise seem relevant. Finally, if you can't design around and you believe that your product may infringe, the question is asked, you have to ask yourself, is it reasonable? Should I take a license under this patent? Should I approach the patent owner and say, look, perhaps I can get a license? And of course, if your activity is licensed, then there's no infringement. So these are the questions that prudent companies typically ask after they've identified a patent before they actually go to the trouble of challenging the patent. But if licensing is not an option and you determine that you infringe, patents can be challenged for their validity. And in the US, there's basically two different forums to do that. In our United States district courts, patents can be challenged, and at the Patent and Trademark Office, in a very different set of proceedings, patent can also be challenged. Just very briefly, the district courts are federal courts in the United States. They are located all over the US in every state, but they adjudicate strictly federal law. And so the law is the same in terms of patent law that is applied regardless of the court in which you find yourself. Let's talk a little bit about district court litigation so you'll understand what the advantages and perhaps disadvantages can be of a patent office challenge. First of all, in district court litigation, patents can be challenged under any recognized legal theory. You're not limited. As we'll see in a minute, under certain patent office proceedings, you can only bring a challenge for lack of novelty or lack of inventive step based on a printed patent or publication. That's somewhat more limited than you could do in district court. In district court, you're also afforded extensive discovery. You can ask the patent owner for all kinds of documents and depositions and evidence supporting either your theory of invalidity or non-infringement. In district court, a patent challenger can seek all sorts of equitable remedies. That is, other than money damages. A challenger can seek a declaration that a patent is unenforceable, or that a patent has been misused and can't be asserted against them. A challenger can seek a declaration that the patent was procured through fraud and therefore is invalid for that reason. In district court, there are no limitations on the number of challenges an infringer or patent challenger can raise. And finally, I'm going to use a funny word, estoppel. Essentially, in district court, a challenger is not prevented from raising in later subsequent challenges, if there are any specific defenses that it could have been raised in the earlier proceeding. And as we'll see at the patent office, that's not the case. Now, some disadvantages of district court litigation. First of all, a challenger has to have standing to be in court. That means you either have to have been sued or you have to prove you are about to be sued. So you couldn't just upon learning of a competitive patent decide to challenge its validity in district court. In district court, the burden of proving invalidity is much higher than at the patent office. We say in district court, it has to be proven by clear and convincing evidence. We'll find out at the patent office, proving invalidity simply must be proven by a preponderance of the evidence, which means just a little bit more likely than not that it's invalid. In district court litigation, the judges are not technical. They are not scientists. And if you have a jury, you really can bet that they are not scientists. And if you have a difficult challenge, technically, on the merits, you may get a judge or a jury who just doesn't understand the technology. Claim construction. Every patent ends with what we call claims. Claims are one-sentence statements of what the invention is. A patent can have one claim, a patent can have hundreds of claims. Obviously, if a patent has hundreds of claims, there are hundreds of inventions that are included in the patent. Very typically in the patent office and in district court, the question of whether an embodiment infringes or whether a claim is invalid will turn on the interpretation of a phrase or a word. And so both judges in district courts and the patent office will engage in a construction or an interpretation of a disputed claim term. In district court, the way the rules work is you could actually get a narrower construction than at the patent office. And that's a disadvantage if you're a challenger, because the broader the claim is, the easier it is to invalidate. And finally, the time frame. District court cases last much longer than proceedings at the patent office. Other drawbacks of district court challenges: they're expensive. They cost a lot more than PTO proceedings. AIPLA has statistics on how much. They can range from, depending on how much is at stake, from $1 to $10 million. We picked 2.4 as a fairly typical amount, as opposed to a patent office proceeding, which can be undertaken for a few $100,000. Still a lot of money, but much smaller than district court. All right, types of US PTO proceedings. I'm going to talk about inter partes review and post-grant review. Mr. Park will talk about ex parte reexamination. We will not talk about derivation proceedings and protests because they're very seldomly used. And I dropped a footnote just to let you know that there was another proceeding called CBMs, Covered Business Method Challenges, but those expired just a month or two ago on September 16th. So they are not accepting any more petitions for challenges to business method patents. This isn't terribly important, but just to give you a flavor of the way the Patent Office has gone, over the years, they have added more and more proceedings available to challengers to challenge patents. And 30, 40 years ago, we really only had protests at the Patent Office. In 1981, they issued an ex parte reexamination proceeding. They added some more in 1999, and in 2012, they added yet more vehicles for challenging patents. And the reason was because there was a sense over the years that our district courts became overburdened with patent infringement litigation. A lot of the patents were considered to be of questionable value. And so the proceedings instituted in 2012 were really designed to bring patents back to the Patent Office and let the body that issued the patent be the one to evaluate its patentability. And that's common in every country of the world. The US was really the last to get on board with a robust series of proceedings at the Patent Office. Inter partes review is probably the most common, the most popular vehicle for challenging patents at the Patent Office. Really takes what used to be a re-exam and turns it into a mini trial. But first, all patents are eligible to be challenged under this proceeding. The challenger is fully involved from day one through the end of the trial. In some of the other proceedings, the challenger submits a petition, and then they're done. They're out of it. Here, the challenger participates the entire way. But the scope of the challenge is limited. A challenge in inter partes review can only be made under a lack of novelty, and that's a common feature for patent systems around the world, and obviousness. Elsewhere in the world, that's called inventive step. It's the same concept as var obviousness. Those are the only two grounds for bringing a challenge in an inter partes review. There is a very limited amount of discovery that's permitted at the patent office. In district court, it's wide open. Patent office, much more limited. The trial at the patent office is presided over by 3 administrative law judges. There will be a senior judge and 2 junior judges. Under the statute, once a patent is challenged and the board decides to institute the inter partes review, the patent owner has an ability to amend or add claims. However, that's extremely restricted. It's been very seldom granted the ability to do that, but when it is granted, the patent owner can actually amend or add claims in a way that the challenger's prior art doesn't apply anymore. And if the claims are accepted, the IPR challenge, the inter partes review challenge, is terminated. Happily, there is a proceeding is of limited duration. So from the day the proceeding is instituted, a final written decision has to be issued within 12 months. And that's good news for anyone that's ever been in our district court system, where a case can easily go 2.5 years or 3 years to get a final judgment. Since 2012, when inter partes reviews became an officially sanctioned challenge tool, there have been more than 10,000 petitions filed. We're averaging between 1,200 and 1,500 a year. So as you can see, this is a very popular vehicle for patent infringers. Very briefly, this is a timeline of how these proceedings go. A petition will be filed on day 1, and within 3 months, the patent owner files what we call a response. And they don't have to respond on the merits. They can simply respond by saying the petition is defective. Within 3 months after that, the board makes a decision. Either they institute the review or they don't. If they do, the final decision is due 12 months from the date of the decision on the petition. After a review is instituted, various things happen along the way. Motions are filed, papers are filed, some discovery goes on, and then there's an oral hearing. And at that oral hearing, there's no witnesses. There's just attorneys who stand up and argue the positions of the parties, and then a decision comes out. It's much more streamlined than our district court proceedings. Very briefly, the other proceeding I said I would talk about is post-grant review. Now, this is not a proceeding available for any patent. This review, this challenge, is only available for patents whose earliest filing date is on or after March 15th, 2013. So essentially newer patents. I won't get into the reasons why that is, but if a patent's earliest filing date precedes March 15, 2013, post-grant review is not eligible for a challenge. The other limitation on post-grant review is that it must be filed within 9 months after grant. Beyond 9 months, the challenger has to use inter partes review. Before 9 months, post-grant review is available. Interestingly, the challenge can be on any ground of patentability. It's not limited to prior art the way an inter partes review is. So if a challenger wanted to bring a challenge based on sufficiency of disclosure or inadequate description or anything else, it can be done in a post-grant review. Like inter partes review, certain discovery is permitted. Trial is presided over by administrative law judges. The patent owner's ability to add or amend claims is restricted, and the duration of the proceeding is fixed. So really, if you're a challenger, whether you bring a PGR, post-grant review, or an IPR is going to depend on when you file and what the basis of your challenge is. This slide is a little bit confusing. I'm going to gloss over it quickly by saying, in the usual case, when a party is sued for patent infringement, oftentimes they consider filing a petition at the patent office pretty soon thereafter, for a couple of reasons. First, it's much less expensive and more efficient to adjudicate your invalidity claim at the patent office than in district court. Second, and more important, if the patent office decides to institute your IPR challenge, the district court will stay or essentially stop the litigation and wait for the patent office. And you see the red arrow going up pointing to a stay. And that's a real advantage if you are the patent challenger or the defendant in district court, because then the other issues in the litigation infringement is put on hold, and you essentially go forward with your invalidity challenge at the patent office. You'll get a final written decision within 12 months. And if at any point in time the IPR is settled, well, of course, there's no trial. And very often, a settlement at the patent office will rope in a settlement of the district court action as well. If there's a final written decision that says the patent is invalid or unpatentable, very typically the patent owner will appeal to the next higher court, and that could take another year. So there's a lot of advantages to bringing your validity challenge at the patent office, even though you find yourself in district court. I'll go through this quickly. So the question you have confronting you now that you know about both types of proceedings is, do I challenge in district court or do I go to the patent office? Let's assume, for example, for a second, both are available to you. Well, does the nature of the decision maker make a difference? In the patent office, you've got technical judges whose background maps quite squarely on the patent claims. In district court, you have a lay judge and lay juries who might not understand the technology. Claim construction will generally be broader in the patent office and narrower in the district court, and that favors patent challengers. Evidentiary burdens. Remember, we said earlier, there is a lower standard of proof in the patent office than there is in district court. So you have to ask yourself, are the issues so close that the quantum of evidence required would actually make a difference? Nature of evidence required. In the patent office, your evidence is paper only. In district court, of course, you can bring in witnesses. And if your invalidity case needs an expert witness to testify on your behalf, district court might be a better, this factor would favor district court. Discovery opportunities, very limited in the patent office, very broad in district court. Does your invalidity case need a lot of discovery? Because you'll get that in district court, but not at the patent office. I will skip over participation rights because those are the same in both forums. Are the claims fixed or fluid? In the patent office, the patent owner can change the claims. It doesn't happen often, but they can. In district court, they cannot. So the target remains the same. I won't go into the rest of these, but there are differences. As we said, the cost of district court action is much higher than that of the patent office, and the timing, the district court action takes longer than the patent office proceeding. Settlement. Patent office proceedings settle just as frequently as district court proceedings. If there is to be a settlement, it's in your favor as the challenger to do that prior to the final decision, because of estoppel provisions and because of other tactical reasons that might affect your litigation. If a case is settled, it effectively terminates the patent office proceedings, the IPR and the PGR. Settlement has to be in writing, and a settlement, an instituted IPR, frankly, is a credible threat to validity early in litigation. Because if the Patent Office institutes, that means they have found there is a substantial likelihood that at least one claim may be invalid. Well, if you're the patent owner and the Patent Office has issued that ruling, now you're feeling somewhat vulnerable to the challenge of your claims, both at the Patent Office and in litigation. And so at the point in time when the PTO decides even to institute one of these proceedings, that can have a very serious and important, a compelling effect on settlement of these proceedings. This is a chart from the Patent Office's own website, and it covers an 8-year period, and it shows institution rates. In the beginning, 13 and 14, the institution rates were pretty high because a lot of the patents brought to them were really of suspect value. But as you can see, the numbers have leveled off somewhat. Still pretty high though, in the 60% range. That means for every 100 petitions for review they're getting, the Patent Office is instituting review on 60 of them, 63, which is pretty high considering that that is the organization that granted the patent to begin with. This is an institution chart really by technology area. See that in the electrical and computer and business method, they're a little bit higher than they are in bio and pharma. And the reason for that is electrical and business method inventions tend to be based on very predictable technologies, computer software. Bio and pharma is really a more unpredictable technology area. And so it is harder to allege and prove obviousness in an unpredictable art than it is in one that's more predictable. So these numbers aren't really surprising. Whoops. Let's look at outcomes. I'll look at this slide very briefly. Again, this is for an 8-year period from 2012 to 2020. About a third of all cases overall, the Patent Office denied institution. About another third, I'm down here in the purple, settled. For those that went forward, they break the chart up here in various shades of blue. About 21%, there was a final written decision in which all claims were found unpatentable. There was about 7% of the decisions found all claims patentable, and 6% of the decisions 6% of the cases, there was a final decision that was mixed. In other words, some claims patentable and some claims unpatentable. If you're a challenger, these are some pretty good numbers for you. These are encouraging. Settlements. Just want to focus on the difference between settlement statistics at the Patent Office before the board institutes, and we're going to compare them to after institution. So before institution, you can see over the years that about 14–15% of cases settle. However, if you look at settlements after institution, the rates go up higher. And the reason for that is quite clear. After the board institutes, the patent owner actually feels somewhat threatened by the board's decision, and they realize their claims are at risk. With that, I will turn over to Mr. Hyunseok Park, and I will give him the screen.
Thanks, Mike. Hello, my name is Hyunseok Park, and I'm an attorney at Sughrue Mion. Further to Mr. Dzwonczyk's presentation, I'm going to talk about Ex Parte Reexamination, which is another USPTO proceeding. After introduced in 1981, Ex Parte Reexamination has been used as a proceeding to challenge a patent. In the chart of the slide, you can see that the number of filing of this proceeding has been increased until 2012, but started decreasing since 2013. This drop might be due to the availability of new USPTO proceedings, such as inter partes review, which is also called IPR, and post-grant review, which is also called PGR. And this seems to indicate that IPR and PGR are more attractive proceedings than re-exams. However, the re-exam is still an available option for challenging patent provided by the USPTO, And still a good number of re-exams is filed every year as seen in the chart. So let's take a look in more detail about the key feature of the re-exam. The first feature is a very unique feature of the re-exam. Different from other USPTO proceedings and district court litigation, the re-exam is the only anonymous mechanism that may be employed at the USPTO to challenge patent. Anonymity can be important, especially when a petitioner does not want to reveal its identity. As discussed at the beginning of the second session, a patent to challenge can be identified by receiving a cease and desist letter from the patent owner. In such a case, the anonymous mechanism might not be beneficial, as a patentee is likely to be able to track down who has started the proceeding. However, the patent to challenge can be also identified by the petitioner in the course of in-house patent search, due diligence, freedom to operate analysis, and even during prosecution, as Mr. Dzwonczyk explained earlier. Such cases are different from the case where the petitioner received the cease and desist letter from the patent owner, since the patentee might not know yet about the petitioner. Therefore, the re-exam is still an attractive proceeding to challenge the patent if the petitioner especially want to remain anonymous in the proceeding. Another thing to note about the re-exam is that it is the least expensive way of challenging patent. The chart here shows the average cost for the re-exam and IPR. Currently, the USPTO filing fee for the re-exam is about $1,200, but this can be done even at the filing fee of about $6,000 if the petitioner wants to proceed with a streamlined request. The streamlined re-exam request was introduced to make the re-exam filing financially less burdensome for petitioner, requester with limited resources. And the average attorney fees for the re-exam is about $20,000. In contrast, the USPTO filing fee for the IPR is about $19,000 just for filing the petition. And there is also the post-institution fee, about $22,000. And even the average attorney fee for the IPR is over $300,000, which is more than 15 times higher than the average attorney fee for the re-exam. Therefore, definitely there is a great amount of difference between the cost for the re-exam and IPR. And in addition, no legal estoppel is created by the re-exam proceeding. As Mr. Dzwonczyk explained earlier, estoppel is a legal principle that prevents someone from arguing something that contradicts what they previously said. So no estoppel means technically the petitioner can assert the same argument against the same patent, and thus there will be less pressure in the proceeding. This is different from other USPTO proceedings. For instance, in IPR and PGR, once the petitioner receives a decision, the petitioner is not allowed to challenge the same patent based on the same ground that was already raised during the prior proceeding. In addition, the petitioner is not also allowed to challenge the same patent based on the ground which could have been raised in the prior proceeding. So this could be another benefit in pursuing the re-exam over other USPTO proceedings. And with regard to the ground for challenging patent, in the re-exam, novelty and obviousness ground may be asserted. This is the same as the inter partes review, IPR, but different from post-grant review, PGR, where other grounds such as subject matter eligibility under 35 USC 101 and written description or enablement requirement under 35 USC 112 may also be pursued. This means that if you'd like to argue invalidity based on written description requirement, which is a popular ground for invalidating antibody patent, or based on patent subject matter eligibility, which has been also greatly asserted for diagnosis method patent or software related patent, then the re-exam cannot be considered as a proceeding to invalidate such patent. Next, processing speed. According to the statistics released by the USPTO December last year, the average pendency of the re-exam, which is between the filing date and the certificate issue date, was about 26 months. This is relatively slower and lengthier as compared to other USPTO proceedings. For instance, in IPR, the institution decision is made within 6 months after filing a petition, and then a final decision is made within a year, which means that the maximum duration is 18 months. So with regard to the processing speed, inter partes review or post-grant review seems to be a more attractive proceeding as compared to the re-exam. But another thing to consider is that the median pendency for the re-exam about 90 months, which is much shorter than the average pendency of about 60-20 months. And 19 months is a period even comparable to 18 months of other proceeding. So the pendency of the re-exam may vary depending on each case. For instance, if you found a prior art reference which teaches each and every limitation of the patent claim, and the determination on novelty issue based on such prior art can be easily made. And let's say that if the patent specification does not provide any reasonable ground for amending the claims to distinguish over such a prior reference, then the pendency of the re-exam could be shorter than the average. And thus, maybe in that case, the period for re-exam could be comparable to 18 months of the IPR or PGR. Therefore, the selection of the proceeding should be made in view of your specific case, as well as the average processing speed of the re-exam and other USPTO proceeding. Next, participation. In terms of ex parte reexamination, ex parte is Latin for from one party. As can be hinted by this name, ex parte reexamination does not allow the third party petitioner to submit an additional argument in response to the patent owner's argument during the procedure. So if you file a re-exam request to assert invalidity of others' patent, you cannot do more than preparing and filing the initial request for re-exam. And then you have to wait to see how the proceeding goes and is decided. In contrast, in IPR and PGR as well, the petitioner may participate in the procedure and thus may submit a reply in response to the patent owner's argument. Therefore, with regard to the participation issue, definitely the re-exam is a less attractive proceeding as compared to inter partes review or post-grant review. Lastly, let's take a look about the success rate of the procedure. The chart here shows the percentage of cases where all claims, some claims, or even no claims are canceled. As you can see, both of the re-exam and IPR show that no claims have been canceled in about 20% of the cases. So the failure rate for the both proceedings seem to be around 20%. However, in the re-exam, in about 12% of the cases, all claims have been canceled, while in about 66% of the cases, some claims have been changed or canceled. In contrast, in the IPR, in 62% of the cases, all claims have been canceled, and in 18% of the cases, some claims have been changed or canceled. So this appears to indicate that the IPR shows much higher success rate overall. However, in the re-exam, about 90% of the initial request is granted, while in the IPR, about 56% of the initial request is granted, which is called institution in IPR. Since the chart here shows the success rate only, for the granted cases, not for the entire cases. If the success rate for the initial request is reflected here, the success rate for the IPR would increase while the success rate for re-exam would increase. In addition, if you just need to invalidate the independent claim, which has the broadest scope among your claim set, the success rate for the re-exam might be comparable to that of the IPR. This is because in the chart, some claims changed or canceled means that at least the independent claims have been canceled or changed, as it is the weakest claim in terms of invalidity based on prior art. Therefore, considering all of the facts discussed, like the IPR, the re-exam is also an attractive proceeding to invalidate patent in terms of the success rate. So thus far, we have discussed various features of the re-exam and compared it with the feature of other USPTO proceedings such as IPR and PGR. As you have seen, there are many aspects of the proceeding to consider in selecting the best course of action for your case, such as anonymity, cause, estoppel, ground for invalidity, processing time, participation, and success rate. And as a last part of the presentation, I prepared 3 different hypothetical fact scenarios, which might be helpful to understand the key features of the proceedings that we discussed earlier. And the first fact scenario is shown in this slide. In here, in this scenario, company X receives a patent cease and desist letter from company Y. An attorney for company X advises that company X has a weak case for asserting invalidity based on novelty and obviousness ground, but has a very strong case for asserting invalidity based on the written description requirement. The patent has been issued 1 year ago. And the question here is, what course of action should company X pursue for invalidating the patent? Maybe let's think about this issue for 20 seconds. So here, my proposed course of action is district court litigation. This is because in this fact scenario, company X has a weak case for asserting invalidity based on novelty and obviousness ground, but has a very strong case for the asserting invalidity based on written description requirement. However, in the re-exam and IPR, the ground for invalidity based on written description is not permitted. Therefore, the remaining procedure here are PGR and district court litigation. These 2 proceedings allow asserting invalidity based on written description requirement, but PGR can be pursued only within 9 months from the issuance of patent, as we discussed earlier. Therefore, here, the remaining available option is district court litigation. And in a hypothetical fact scenario 2, company X identifies a patent owned by company Y in the course of an in-house patent search. An attorney for company X advises that company X has a strong case for challenging the patent on novelty and obviousness. However, company X does not want to reveal its identity in challenging the patent. So question here is, what course of action should company X pursue for invalidating the patent in this scenario? So let's think about this issue for 20 seconds again. So in this scenario, my proposed course of action is ex parte reexamination. As we have seen earlier, the re-exam is the only anonymous mechanism that may be employed at the USPTO to challenge the patent. Different from the re-exam, a challenger must identify the identity in other USPTO proceeding and also district court litigation. In this scenario, the patent to challenge has been identified in the course of an in-house patent search. And the patentee might not know yet about the company X. And as the ground for challenging invalidity is novelty and obviousness, which is permitted in the re-examination proceeding. And also company X does not wish to reveal its identity. Here, the re-exam may be the reasonable course of action that company X may pursue. And this is the last scenario. Here, company X receives a patent cease and desist letter from company Y. An attorney for company X advises that company X has a weak case for challenging the patent on novelty and obviousness, but has a strong case for written description. And the patent has been issued 2 months ago, and company X budget is limited, and company X wishes to receive a decision as soon as possible. So question here is, what course of action should company X pursue for invalidating the patent? So another 20 seconds to think about this case. So in this scenario, my proposed course of action is post-grant review. First of all, here the written description requirement provides a strong ground for invalidating the patent. As we have seen, there are only 2 proceedings which permit written description ground for challenging patent. They are post-grant review and district court litigation. However, another fact to consider is that company X budget is limited, and also company X wishes to receive a decision as soon as possible. As Mr. Dzwonczyk explained earlier, the USPTO proceeding is a less expensive procedure as compared to the district court litigation. In addition, the maximum duration for the post-grant review is 18 months, which is generally considered to be shorter than the district court litigation. Therefore, PGR seems to be a more attractive proceeding to company X in terms of its processing time and cost. Lastly, in this scenario, the patent has been issued 2 months ago, which satisfies the timing requirement for the PGR, which is within 9 months from the issuance of the patent. Therefore, in this scenario, the PGR may be the reasonable proceeding for company X to challenge the patent, which is owned by company Y. So this is the end of our presentation. And if you have any question, please feel free to contact me or Mr. Dzwonczyk. And I speak Korean, so if you are more comfortable speaking or writing in Korean, please do not hesitate to do so. Thank you for watching and have a good evening.